Verdict, count 1. We, the jury, duly impaneled and sworn in the above entitled action, upon our oaths, do find the defendant, Lori Daybell, as to the crime of count 1, conspiracy to commit first-degree murder occurring on or about July 11, 2019, guilty.
Immediately after the guilty verdict was read in Lori Daybell's conspiracy to commit murder trial against her fourth husband, Charles Vallow, Judge Justin Beresky dismissed the jury to begin what is called the aggravation phase prior to sentencing. This phase is initiated by a motion from the prosecution to present evidence of aggravating factors in the commission of the crime. In this case, the jury would have to find beyond a reasonable doubt that the crime committed was particularly dangerous, that the defendant's actions caused the death of the victim, that the death of the victim caused emotional harm to the victim's immediate family, and that there was an accomplice involved in the killing. After the prosecution presents evidence of aggravating factors, the defense can present evidence to counter the aggravating factors, known as mitigating factors. In this case, Lori Daybell might focus on the fact that she had never before been arrested or had a proven criminal history, and that she cooperated with authorities. But given Lori's past patterns, it's doubtful she would argue any kind of mental health issue, and it would be laughable for her to claim that she has any kind of remorse, since she's repeatedly asserted that no one was murdered in this case. Although she could continue to refer to the incident as a family tragedy or self-defense, it's not likely a jury would be receptive, since she failed to offer any evidence of self-defense during the trial. In Arizona, the jury typically decides whether the aggravating factors outweigh the mitigating factors. If they do, the judge could impose a harsher sentence, such as life without parole. Prior to the verdict being read, Lori Daybell indicated that she might be willing to stipulate to the aggravation phase, meaning that no further evidence would be heard of Lori's malfeasance, and Lori would be agreeing to allow the judge to find that she deserves a harsher punishment without her presenting any mitigating factors in her favor.
Let's both have a chance to review those.
Yes, Your Honor.
Are there any additions or corrections from the state?
No, Your Honor.
How about from the defense? The defense did email my staff requesting an additional paragraph. The defendant is not required to testify or produce evidence of any kind. The defendant's decision not to testify or produce evidence is not evidence of any aggravating factor, which I did include in the bottom third of page 3. Given that, are there any additions or corrections?
No, Your Honor.
Are either the state or the defense requesting any other additional instructions?
No, Your Honor.
If there's an aggravation phase, does the state plan on introducing any testimony or exhibits?
Testimony, I believe, likely from 2 family members, we will limit it. I don't plan on doing openings, just presenting testimony and then argument.
All right. Would the defense anticipate presenting any evidence?
Your Honor, can we just stipulate to that? I mean, the statute says there's only one punishment for this crime. What is this? Why is there an aggravation phase for this specific count?
Much like the guilty verdict, the jury in Arizona has to find whether or not there's any aggravating circumstances. In addition, the jury would still need to find that if it's a guilty verdict, whether or not it's a dangerous offense. Until it's found as a dangerous offense, that sentence that you're talking about wouldn't be triggered. So I think we need to have an aggravation phase regardless. So would you plan on presenting any testimony or evidence in the aggravation phase if there is an aggravation phase?
No, but could I just stipulate to it or not? That's my question.
You can stipulate to aggravation and you can stipulate to whether or not it's a dangerous offense, but I think you should probably wait until we read the verdict to do that. So I guess it will, depending on what the verdict is, we may take another break.
After the jury was sent back to the jury room, the judge asked Lori if she was still willing to stipulate or agree to the aggravating factors, meaning no further witnesses could be called against her. Maybe I'm the only one who noticed it, but it seemed as though after the guilty verdict was read, Lori became annoyed, frustrated, and couldn't seem to get out of the courtroom fast enough. Let's watch.
I'll ask the defendant, you indicated earlier perhaps a willingness to stipulate to aggravating factors. Is that something you want to do, or do we want to go through this aggravation phase?
I'm willing to stipulate to it, Your Honor. All that it is the dangerous phase. Is that correct? There's only one statute there's only one sentence.
Well, the jury would need to find, first of all, whether or not this is a dangerous offense first. Secondly, whether the offense caused physical, emotional, or financial harm to the victim, or if the victim died as a result of the conduct of the defendant caused emotional or financial harm to the victim's immediate family. And then thirdly, the offense involved the presence of an accomplice. If you're willing to stipulate to all three of those, we can do that. If not, we'll bring the jury back in.
I will stipulate to it, Your Honor.
All right. You understand that if you stipulate to this instead of a jury finding, well, let me back up. You understand the jury would have to find these aggravating factors beyond a reasonable doubt?
Yes.
All right. And do you understand that if you stipulate to these factors instead of a jury doing it, I could also find additional aggravating factors at sentencing?
Sure.
Has anyone forced you or threatened you in any way to get you to stipulate to these factors?
No.
Has anyone promised you anything to get you to stipulate to these factors?
No.
Have you had any drugs, alcohol, or medication in the last 24 hours?
No.
Do you agree that pursuant to the jury's verdict of guilt, that this would be a dangerous offense because a deadly weapon or dangerous instrument was used?
I'm stipulating to it.
Do you agree that that's that this is a dangerous offense?
Correct.
And you're further stipulating that as a result of your conduct, at least the victim or the victim's family suffered emotional or financial harm?
Absolutely.
And you're also further agreeing that the offense involved the presence of an accomplice?
Yes.
Is the state satisfied with the colloquy?
Yes, Your Honor, it appears it's knowing voluntary. Made.
All right, the court does find that the stipulation to those three factors was knowingly, intelligently, voluntarily made. I will accept the defendant's stipulation. At this time, I'm going to bring in the jury and release them from the admonition. Before we do that, well, as my staff's lining up the jury, do you want to have a sentencing date within approximately 30 days, or do you want to wait until after the next trial to be sentenced on this matter?
What does the court prefer?
It doesn't matter to me. Maybe you want to talk to your attorneys or advisory counsel about that. We don't have to do it right now. You can do it in a few minutes.
So when the judge asked Lori if she realizes that he can find additional aggravating factors, she answered, sure. When asked if she agrees it was a dangerous offense, she belligerently answered, I'm stipulating to it. Lori also admits that the victim's family endured significant emotional harm by answering absolutely. And when asked if she was stipulating to the presence of an accomplice, Lori gave a longer than usual pause before answering yes. Finally, the judge asks Lori whether she prefers to be sentenced in 30 days or wait until the completion of the next trial, to which Lori replies by asking what the court prefers. It seems as though she's fully given up by this point and just wants to get back to her cozy cell at the Estrella jail.
All right, please be seated. Do you want to talk to your advisory councils briefly to discuss whether or not you want to proceed to sentencing or wait until after the next trial?
If we could just wait till after the next trial, Your Honor.
Okay. So I'll hold off on ordering a pre-sentence report until we resolve the next remaining case. I've already set the dates and we have a status conference in mid-May on that. So unless there's anything else from the state's perspective,
Your Honor.
from anything else from your perspective?
Nope.
All right, we'll be at recess on this matter.
The reason I think Lori's behavior during the potential aggravation phase is significant to mention is because we can no longer dismiss her behavior as simply attention-seeking or a desire to be in the spotlight as much as possible. If her motives were truly that shallow, I think she would have taken the opportunity to face off against Trina K and continue to push her weak arguments. Arrogant people tend to be very defensive and have a strong need to explain themselves and to be understood. I think what we're seeing here is another slip of Lori's public mask. I think we're seeing the cracks in her veneer that show up when she's been publicly shamed. Remember that at her core, Lori and other people with narcissistic traits are deeply insecure. They live with the constant anxiety of being discovered as a fraud. Lori later states in a public interview that she was very surprised by the guilty verdict. This reveals how very unaware she is of how her antics and lack of evidence are being perceived by the jury and the public. As Lori prepares for her next trial, I'll be watching for several key behaviors. First, I'll be interested to see if she's learned anything about how to conduct herself in the courtroom. Although Judge Beresky has been very patient with her, she revealed in her interview with Arizona Family that she was surprised to hear Brianna Whitney characterize the judge's treatment of her as patient and understanding. It's been clear up to this point that Lori sees herself as a victim of the system, and she feels robbed of the opportunity to defend herself. Next, I'll be interested to see if she intends to call any witnesses and if she changes her tactics around subpoenaing witnesses who actually have material evidence to contribute to her defense. It appears that in the last trial, she used her constitutional right to not put on a defense as a mask to hide the fact that her witnesses had no credibility and no valuable information to offer. It's a pretty common narcissistic point of view to feel entitled, and Lori certainly expected the jury to acquit her because she's not obligated to put forth a defense or to testify. I've also long suspected that Lori never expected that she, Alex, or Chad would ever be caught, much less tried and convicted. The next trial will be her last opportunity to redeem herself publicly for the embarrassment she suffered in Charles's trial. There were a slew of objections. Lori was not able to ask all of the questions that she wanted to. And in the last trial, it was apparent that all Lori cared about was finding out what everyone else was saying about her rather than putting on an actual defense. Either way, we will see if Lori has the stamina to endure more public humiliation or if she will give up and accept defeat in the next trial. There's no doubt she's ready to get back to her cushy accommodations in Idaho, and I suspect that no matter the outcome, she will craft a new delusion where she gets to play the savior from some marginalized inmates and avoid the uncomfortable truth of who she really is and what she's really done. I hope you'll join me as I continue to report on the case, but more importantly, I hope you'll come with me on this learning journey of how to identify and defend against manipulation and control. For one-on-one coaching as well as e-courses, please visit my website at third-first.com. Thanks for watching, and please share with someone who you know needs this content. Take care of yourself, and I'll see you soon.